Hello, my name is John Lober, a professor of classics at the University of Mississippi in the current and inaugural chair of the Faculty Senate Faculty Grievance Committee. Welcome to the training video for the new Faculty Grievance Policy at the University of Mississippi. In this video, you will be hearing the voices of members of the inaugural Faculty Senate Faculty Grievance Committee who created the Faculty Grievance Panel manual and the video that it goes with, this video right here. In order of appearance, they will be myself, Kristen Swain, Professor of Journalism, Hans Sinha, Professor of Law, Jamie Wagner, Professor of Pharmacy Practice, Kristen Austin, Director of the Psychological Services Center and Professor, and George McClellan, Professor of Education. We will walk you through the process, introducing topics in the order they appear in the Faculty Grievance Panel manual. We would like to offer our deep gratitude to you for your volunteering to be part of the inaugural Faculty Grievance Pool. First, a little background. This policy was the result of several years of work by a few Faculty Senate committees. The purpose was to replace the old policy that was far out of alignment with the guidelines and recommendations of the American Association of University Professors, or AAUP, with regard to institutional regulations on academic freedom and tenure. To be precise, AAUP guidelines state that a faculty-only committee, elected by faculty members, should determine whether a complaint by a grievant is in fact grievable and should move forward to a hearing, and that this hearing should likewise be conducted by a faculty-only committee elected by the faculty. Moreover, after extensive research, we determined that the old policy was far out of alignment with the best practices of our peer institutions in the Southern University Group, or SUG. The current policy reflects years of dedicated effort and negotiations with the university administration to create what we hope will be one of the best grievance policies in the United States, a great step forward in furthering shared governance and academic freedom on campus. First, let's talk about the body you belong to, the Faculty Grievance Pool. The pool is different from the Faculty Grievance Committee, which is a Faculty Senate standing committee. Your body represents members elected from each school on campus, plus the library. Every year, your school will elect 3 members below the rank of chair to serve on the committee. At least one of these 3 must be tenured track, and at least one must be non-tenured track faculty. The pool will consist of 30 people. Faculty members serve on the pool for 1-year terms from August to July of the academic year following their election. For the inaugural term, members shall serve 1.5 years from January 2025 to August 2026. Faculty members are only expected to serve on the faculty grievance pool when they are actively employed by or on contract with the university. To be more precise, you're only going to be part of a hearing when you're on contract. So let's say a grievance has been filed to the Senate committee, and the committee decides that it is grievable. We'll talk more about that later. What happens next now is that the chair of this committee, the chair of the standing committee, will use a random number generator to select 5 faculty members from the pool of 30, the body that you belong to. The chair will then contact these members to complete a secure survey on Qualtrics to ascertain whether each member can be fair and impartial during the hearing. Once this has been determined, the chair of the grievance committee will share with each panelist a secure box link through the box, University of Mississippi box, that will contain read-only access to the grievance submitted by the grievant and all other grievance materials. The panelists will also receive a doodle poll to determine what times each member can meet for a hearing. The hearing must take place within 15 working days of the time that the grievance committee has determined that a submitted grievance is eligible for a hearing. It is important that panelists be as flexible as possible in choosing times for the hearing. Choosing times towards the end of the 15-day period is also useful, so that the panel has adequate time to review the case and the submitted witness lists and to determine whether or not the panel would like to call additional witnesses or university officers to testify. One thing the panel should do right away is elect one of their own to be the presiding officer of the hearing. This is important because the presiding officer will communicate with and coordinate the participation of all witnesses and resource persons and university officers in the hearing. The chair of the grievance committee also needs to know who this is right away so that they can make this person, the presiding officer, the co-host of the scheduled Zoom meeting that the grievance hearing will take place on. When it comes to recusals, panelists should make recourse to it very sparingly. It only really applies when it comes to their ability to participate in the hearing impartially. If a panelist is in the same department as the grievant or the person being grieved, or if they are a close friend or family member of either party, or are involved in the matter under dispute or have a conflict of interest, then they should absolutely recuse themselves. If there is a need for a recusal, the panelist must contact the chair of the grievance committee by way of the qualtrics that was sent by the chair to determine if a panelist is eligible. And they should do it within 2 working days of receiving that qualtrics. The chair will then select another member from the pool using a random number generator.
The way we handle disputes here directly impacts our work as faculty, which depends on academic freedom, respect, integrity, and fair treatment. These values must extend to how we resolve internal conflicts. Since the creation of the earliest universities, academia has rested on a foundation of faculty input and shared governance. A robust and well-functioning grievance procedure is foundational to every process, procedure, right, and privilege on our campus. Your potential role as a hearing panel member is vital. If selected, you'll help to resolve specific disputes. You'll also ensure due process and maintain the professional standards that make meaningful scholarship and teaching possible at UM. Our new grievance policy represents a significant step forward in shared governance at Ole Miss. It establishes clear procedures and puts the responsibility for evaluating grievances where it belongs, with faculty peers who understand academic work. As a panel member, you'll serve 3 essential roles. First, you'll be a guardian of due process, ensuring fair hearings for all parties. You'll listen carefully to evidence and testimony, ask probing questions, and collaborate with fellow panel members to reach reasoned decisions. Second, you'll bring your faculty perspective and understanding of university policy, academic values, and professional standards to each case. Third, you'll serve as a trusted peer to colleagues facing serious professional challenges that affect their careers and well-being. Well, next, let's walk through what happens when you're selected. The Faculty Grievance Committee will randomly choose 5 faculty members from the pool to form a hearing panel, with no more than 1 member from any single college or school. If selected, your first task is a self-check for any conflicts of interest that might affect your impartiality. The committee will provide all necessary documents through our secure system. Once formed, the panel will select 1 member to serve as presiding officer. This person takes an additional responsibilities to ensure that the hearing runs smoothly and fairly. The committee chair will schedule the Zoom hearing and make the presiding officer an alternate host, sharing the link with all of the participants. The presiding officer's pre-hearing duties are time-sensitive. Within 10 working days before the hearing, both the grievant and the respondent must submit their lists of witnesses, resource people, and university representatives. The presiding officer will then schedule a planning meeting with the panel to review these lists and determine if additional witnesses might be needed. Every participant must receive an official grievance participation email containing the date, time, expectations, and Zoom link. This email serves as their virtual ticket to the hearing. During the hearing itself, confidentiality is paramount. You must not copy, capture, or discuss any records or comments outside the process. The hearing follows a structured format. The grievant presents for 1 hour, followed by the respondent's hour. Then the grievant gets a 15-minute rebuttal. The presiding officer manages the recordings, witnesses, questioning, and deliberations. The presiding officer will start by beginning the Zoom recording to create the official record of the proceedings. During the presentations, your role as a panel member will be to listen carefully and objectively. You might need to ask questions to clarify points or better understand the situation. You're not there to advocate for either side, but to help ensure a fair process and reach a reasoned decision based on the evidence presented. It will be similar to serving on a peer review committee. You're bringing your professional judgment and academic experience to bear on important matters that affect your colleagues. The key difference is that you'll be evaluating whether university policies were properly followed rather than reviewing academic work. The presiding officer will carefully manage witness participation. Each party is responsible for ensuring their witnesses know when to join the hearing, but the presiding officer controls when witnesses enter from the Zoom waiting room. Witnesses will only be present when they're actively contributing or answering questions. If a witness is late, they get a 1-minute grace period unless they've already notified the presiding officer that they need a brief delay. When all presentations and witness testimonies are complete, the presiding officer will clear the virtual room of everyone except panel members for deliberation. During this private discussion, you'll analyze the evidence presented and participate in an anonymous poll, a simple yes or no vote on whether the grievance is supported. This anonymity helps ensure each panel member feels free to vote their conscience without pressure. After the hearing concludes, the presiding officer will have several important tasks to complete. First, they must ensure the recording is properly converted, uploaded to the Faculty Grievance Committee's box folder, and deleted from their personal computer. This process will help maintain the confidentiality of the proceedings while preserving the official record. Within 20 working days, the presiding officer will submit a comprehensive report through a secure Qualtrics link provided by the Grievance Committee. The report will tell the complete story of the hearing, the panel's decision, vote count, key facts discovered, suggested remedies, and proposed deadlines. They'll also note any unusual occurrences or suggestions for improving the process. This feedback will help the Faculty Senate continually refine our procedures. Next, you'll hear more about the expectations of panel members during the hearing and how you will consider the evidence.
So I'm going to give a little overview of what happens at the hearing for a grievance pursuant to our grievance policy. This is the panel members' duties during and immediately after a hearing. Throughout the policy, the key is that, one of the fundamentals is that it is fair and impartial, perceived to be fair and impartial. And this includes at the actual hearing, the panel hearings. Section B2D of the policy provides some guidance how to ensure the hearing is fair and impartial, and we'll discuss a few of those matters here. One of the fundamentals of our policy is that we keep a record of what happened at the hearing. Once a hearing has been completed and a recommendation finding has been authored, it's then submitted to eventually the provost, who can then review it. So we need to have a record of the hearing. So since our hearings can be done via Zoom, we should use the Zoom option to record our hearings. The presiding officer initiates and controls the Zoom recording, and upon the conclusion of the hearing, he or she should download the recording, the Zoom recording, and deposit into a box folder that's provided for each case. And after confirmation of the fact that that recording has been received in the box folder, the panel presiding officer needs to delete the recording from his or her computer, and also from the deleted file, the trash file of his or her computer. In other words, once the hearing is done and recording has been delivered to the box folder, we don't want a record of that hearing remaining either in the cloud or on a faculty member's computer. So we need to record a hearing, deliver it to the box folder, and then subsequently delete that recording from the faculty members, the presiding officers folder or computer. How we are perceived at the hearing is equally important to the fact that we are being fair. So we want to ensure that when faculty members come to a panel hearing, the hearing for the grievance has been filed, not only are they treated fairly, but that the perception is that they're being fairly treated. So with that in mind, panel members should just be mindful of their demeanor, the body language, how they ask questions. The perception is just as important as the actual fairness. Well, maybe the actual fairness is more important, but we want to make sure that everyone leaves a hearing with the understanding and the conviction that it was a fair hearing, and part of that is the perception how people come across. So just be mindful of how you act, your demeanor, and how you ask question at the actual hearing. At the hearing, it is equally important that in making the determination of the grievance that has been filed, only information that was presented at the hearing is considered by the panel members. In other words, the grievant, the respondent may bring forth different information to the panel members during the hearing, and it's only based on that information that a determination should be made. Outside extraneous information should not be considered at the hearing. Now, presumably everything that's relevant to the matter at hand will be presented at the hearing. There's information that can be obtained through the written into the panel, the policy, how to obtain information that's needed for the panel members. But once the hearing is over and the panel members are engaged in making a determination, the deliberation, so to speak, of the information, only information that was presented at that hearing should be considered. And again, this goes towards making sure that the process both is impartial and fair and is perceived to be impartial and fair. Part of the policy, again, mandates that we keep a record of the actual hearing, including the findings and determination at the end of the hearing. But part of making sure that we have a record of everything means that we need to keep minutes of the hearing. So the policy mandates that minutes of the hearing be kept, and it should be done in conjunction with the hearing, during the hearing itself. One panel member should be selected to keep the minutes. This could be the presiding officer, or the panel members as a whole could decide that somebody else is charged with keeping the minutes. And that's up to the 5 panel members to decide whether they want the presiding officer, when they will select a presiding officer, whether they want the presiding officer to keep the minutes, which might make sense, or whether they want the presiding officer to focus on other things and somebody else, another member of the panel, keep the minutes. Regardless who is chosen to prepare and keep the minutes, the minutes should contain the case name and number, the date and time of the hearing, to reflect those who appear before the panel, approximately time they did so. So in other words, to say so-and-so came before the panel, or the panel, this is the hearing for such a case. The hearing began on such date and time. On such time, so-and-so appeared before the panel. It should be just, the time, 12:05 p.m., so-and-so appeared. What material was presented to the panel, and this could be a general description was presented, and then also the time the hearing was concluded, just so we have a record of the hearing itself. Uniformity is key here, or is important here, so we will provide a form for the minutes, but generally they should contain what we talked about here. In addition, the policy mandates, and which makes sense, that a panel prepare the findings and a recommendation. This may be done in a two-step process or could be done in a one-step process. What I mean with that is immediately after the conclusion of the hearing, the panel should then deliberate and prepare the findings. Holding this deliberation immediately after conclusion of the hearing ensures that first it gets done right away, and secondly, that it is done while everything is fresh in the minds of the panel members. In other words, what the panel should not do is have the hearing and say, we'll come back in a couple of days and do our deliberation. The way life is, it's going to be hard to get the 5 people back at the same time, and memories may fade. So it's always better to do the deliberation immediately, and the policy dictates that the deliberation is done immediately upon the termination of the hearing. And in doing so, the hearing is over. Everyone should be asked to leave the hearing room, and it really should not be anyone left except for the panel members. And the panel members then, by themselves in a room where no one else is present, shall conduct a deliberation. They shall discuss the matter, and based on the preponderance of the evidence, arrive at a finding and decide on recommendation of resolving the grievance. This finding shall be done by a secret majority vote. Once the deliberations has been done and the panel has made a determination that this is what we found and this is our recommendation, we also need to, or the panel also needs to put that in writing. So they can do that at the same time as they're doing the deliberation. If it's a case that may not be very complex, it can be very easy to complete that written deliberation findings immediately, or they can take some time to do it after. And that depends on the hearing, how the panel member wants to do it. The deliberation happens immediately after. They may write the finding and the formal recommendations immediately after, or they may, after deliberate, they discuss and find their findings by secret vote, determine what it's going to be in recommendation. They can then decide we're going to write the formal document thereafter. If they go for thereafter, it has to be done within 20 days. So again, the policy mandates and recommendation shall include the panel findings regarding upholding or denying the grievance, the tally of the panel's vote, and this means the number, who voted so and so, not the identifying who voted for what, but 5-member panel, 5 voted in favor of the grievance, 5 voted against, 3, 4, 4, 3 against, or 2 against, whatever the numbers were, but not saying so and so voted so and so. So it's a number of the tally of the panel's vote. And then the pertinent facts supporting the panel's recommendation, what the grievance was, what the panel found, and why. And then also suggestions of the panel as to any proposed remedies and associated deadlines for such. So this could be one page, could be a couple of pages. But because if in a complex matter, the panel may need a day or a couple of days to actually put their finding recommendation into paper in a presentable format, it can be done right after the hearing, after the deliberation and findings, and the panel members decide we're going to write it together right now, or one person's going to author it, and we do it together. Or they can do it after the hearing. And if they decide to do it after the hearing, which may be the presiding officer gets all information, the panel makes a vote, and they discuss it and make their vote, and they come up with the finding and recommendation, the panel presiding officer may then say, well, I will write this. And then within 20 days, that formal written recommendation and findings has to be completed within formal days. That written recommendation, and in reality, probably going to happen is the panel is going to deliberate, discuss their findings, take their vote, and then presiding officer will be charged with writing the written recommendations and findings within 20 days, and probably going to write it and then concur with the panel members. This is what I wrote. They all approve it, and the written final document should be signed by the presiding officer. That has to be done and submitted, the written form, written findings, recommendations, submitted within 20 days of the conclusion of the hearing to the chair of the Faculty Grievance Committee. So there's a 20-day time period to put the findings and recommendation that was done and arrived at by vote immediately after the hearing into a paper format, but we have 20 days to do that. Upon that 20 days or before, but within 20 days, it shall be submitted to the chair of the Faculty Grievance Committee. The Faculty Grievance Committee will then disseminate it to the respondent and the grievant and the provost. So it could be a one-step hearing, conclude a hearing, deliberation, vote, finding, recommendation, or write it out right there and then, depending on how complex the issue might be. Or it could be a two-step process: hearing, conclusion of the hearing, deliberation, discussion on finding, finding of the finding, vote on the finding and recommendation, and then take a couple of days, 5 days, 10 days, whatever may be needed, for most likely the presiding officer to author that and put that into written context, signed by the presiding officer, and then forwarded to the chair of the Faculty Grievance Committee within 20 days. How this is done, whether it's going to be done in a one-step or two-step process, will really be up to the 5 panel members hearing the committee, hearing the matter, and probably depend upon how complex or how simple the issue may be. But remember the 20 days to get this formal findings recommendation to the chair of the Faculty Grievance Committee. Throughout the process, confidentiality is of utmost importance. So once a grievance has been filed, that grievance is confidential in nature. And that includes the actual hearing, and that the findings recommendations be confidential. So the hearing itself is a closed hearing. Only the party and the witness may come before the hearing are allowed in the room when the hearing is going on. The panel members should keep what happens at that hearing confidential. So they should not discuss this with someone outside of the grievance process. They should not discuss it afterwards with someone and say, this is what happened. There's a confidentiality throughout the whole process. The panel members should put their findings and recommendation in the finding recommendation document, and thereafter it should not be discussed. That's then forwarded through the process eventually up to the provost. So confidentiality is important throughout the grievance process, and especially and equally so important throughout the hearing and after the hearing as well. One thing that the policy mandates is that the hearing is done without the rules of evidence. And this may be confusing to some. The thinking here, in essence, is that these hearings are done by faculty, conducted by faculty. It's a faculty-driven faculty grievance process. It is not a formal court of law process. So the hearings will be conducted with the formalistic rules of evidence that are used in the typical American courtroom. In other words, once a grievance has been filed, the grievance committee has determined it falls within the parameters of the grievance policy. An informal attempt at resolution has proven unsuccessful in resolving the issue. The matter then goes to a hearing. While this hearing is formal in nature, it is conducted without the formal rules of evidence in terms of what may or may not come before the hearing committee, meaning the 5 panel members. A way to look at that is just look at the comparison of the American trial system and the European system. In the European system, they have a system that is based upon what's called the free evaluation of evidence, where virtually everything can be brought forth that's relevant to the trial and or hearing. In the American system, we use formalistic rules to keep things away, material evidence, so to speak, out of the purview of the fact finder, which in our case is the jury. So in the American system, we use very detailed formalistic rules of evidence to determine what material information may be part of a trial and or hearing. The reason for this is that we have a system where our juries, the fact finder, are lay people, and we thus, as a system, as a society, feel the need to keep certain information from those jurors, the fact finders, because we fear they may be swayed by improper matters such as emotions or other improper factors. So we have developed this very formalistic set of intricate and formal rules to determine whether something may be presented at a hearing or not. That's the American system. That is not the system we have developed for our faculty grievance policy. Our faculty grievance policy is more akin to the European system. In that system, they use judges and professional jurors to determine a case. In other words, they serve as the fact finders, whereas in the American system, we pick lay people to serve as a fact finder. So your European system has this implicit trust that their fact finders will be able to determine based upon all relevant evidence and hearing all relevant evidence and make a fair determination based on such evidence. So unlike the American system, the European system permits all relevant evidence to come before the fact finder, and the fact finder is then charged with giving the proper weight to such information. So the system in Europe, under the free evaluation system, which is a system we have adopted in our faculty grievance policy, permits material to come forward without the pre-hearing determination, well, that may or may not be admissible. So our system is more akin to the European system in the sense that we have what we determine or call the free evaluation of evidence. Let me give an example that may clarify this. For example, consider a criminal trial with an alleged confession. In the American system, whether the fact finders, the jurors, will be able to hear about such confession, even know that it exists, will depend upon a myriad of formalistic rules that will be applied pre-trial. Right? To do so, you need to have an understanding from the Constitution and all the case law thereafter interpreting confessions and when it can be admissible. So in an American system, if there were a certain allegation, confession was obtained through force, it would likely be kept out of the purview of the hearing, and a fact finder would never hear about it. In the European system, under a free evaluation of evidence, the confession would come in, but the jury, meaning the fact finder, would be permitted to hear about the allegation of the force to get the confession, and they would then give that information, that piece of evidence, the confession, the proper weight in the overall review of the matter or the information comes before them. So we have adopted as part of our faculty grievance systems and free evaluation of evidence. That means that we don't employ formalistic rules to determine whether a party may or may not present information to the panel. Instead, as per the concept of free evaluation evidence, what a party may want to present may be so presented. The panel members then give such material what they believe is a proper weight in their overall determination of the matter. So in other words, at your hearings, there will be no objection, not admissible because of XYZ rules or Fourth Amendment or Constitution. It will come in as it will be permittably presented by the grievant or respondent as per the free evaluation evidence. You, the panel members, are then free to give whatever proper weight you believe should be given to such information brought before you at the hearing. There is one caveat to this, and that's a relevancy limitation. Just as in the European system, for our hearings, the presiding officer has the right to limit information presented based upon relevance. This authority, however, does not come from formalistic rules of evidence. It comes from the inherent duty and authority of the presiding officer to ensure an orderly and fair hearing. Thus, if some information is so far removed from the issue at hand, the presiding officer may determine it's simply not relevant. This will likely be a very limited situation. There is a possibility that relevance limitation would come in a hearing, but it should be used very sparingly, and it's very unlikely to appear. There's anticipated a relevance issue will arise very not often. If nothing else, the fact that the parties have 1 hour to present their case will ensure that what is presented to you, the panel members at the hearing, is relevant, is important to the matter. If an issue arises in terms of relevance, the presiding officer should err on the side of inclusion. Yet, if something that's being presented is just so totally out of the realm of relevance, just has no bearing whatsoever on the matter, the presiding officer could step in and say, let's move on to something that this is not relevant to this matter. Again, there is a possible relevance limitation on what may come in, but that should be that exception and used very sparingly. So as a whole, our hearing before the panel member is envisioned to use no rules of formalistic rules of evidence, but free evaluation of evidence. So whatever the parties, the grievant, respondent wants to put forth should be accepted and heard by the panel members. Again, you as the panel members are free to give whatever weight you determine to that material, but we will not use formalistic rules of evidence to keep matters out. I hope this has been helpful, and wish you all good luck in effectuating our new policy.
Hello, everyone. Today, I'll walk you through the grievance hearing procedure to ensure that we all understand the process and expectations clearly. The grievance hearing is conducted in a closed setting, meaning attendance is limited to essential participants. The list of those participants are included on this slide. They are the members of the faculty grievance panel, the grievant, the respondents, resource persons selected by the grievant and the respondent, and any witnesses when called. Importantly, this process does not follow the traditional rules of evidence. This flexibility allows for a more comprehensive review of facts, even those that might not typically be admissible in court. During the hearing, the grievant begins with their presentation, including evidence and witness support, with a maximum duration of 1 hour. Following this, the respondent presents their side, also within a 1-hour time limit. After both presentations, the grievant is granted up to 15 minutes to respond to the respondent's presentation. The faculty grievance panel may extend time equally for both parties should they deem it necessary. There are 2 types of witnesses. The first is the called witnesses. These are selected by either the grievant or the respondent to provide supporting testimony. There are no limits to the number of called witnesses. The second type of witness is the panel witness. These are called specifically to assist in resolving the grievance. These witnesses can be asked questions by both the grievant and the respondent. University representatives may be summoned by the presiding officer, the grievant, or the respondent. The presiding officer is also responsible for determining the order, length, and scope of questioning of these hearing participants. After the presentations and questioning, all participants except for the faculty grievance panel will leave the meeting. The panel then deliberates and votes by secret ballot to finalize the recommendation. The recommendation will include several components. First, a determination of whether the grievance is upheld or denied. Second, a vote tally excluding individual vote disclosures. Third, findings of pertinent facts. And fourth, suggestions for proposed remedies and deadlines for their implementation. Finally, within 20 working days of the hearing's conclusion, the presiding officer will submit the panel's recommendation to the chair of the Faculty Grievance Committee. In summary, this process is designed to ensure fairness, clarity, and thoroughness, while also allowing for an efficient resolution of grievance. If there are any questions or clarifications needed about the procedure, please reach out to the chair of the Faculty Grievance Committee.
The presiding officer completes the findings using the blank findings template, which can be found in Appendix F in the Faculty Grievance Pool and Panel Procedure Manual. As the presiding officer, you should note whether the decision that was being grieved was found to be upheld or denied based on the information that was presented during the hearing. You should also note how many of the panel members voted for the decision to be upheld and how many of the panel members voted for the decision to be denied. Because these votes were anonymous during the Zoom hearing, you will only note the number, not who on the panel voted for either choice. In the pertinent facts section, you will briefly indicate what facts from the hearing were critical to the decision and remedies proposed. You should not add any personal opinions in this section. You should keep this section brief and focused on the facts that the panel used to arrive at their decision. In this example, the pertinent facts were: 1. The grievant was asked to perform work duties by the chair that were not indicated in their job description. 2. The chair did not respond to the grievant's 5 requests to meet via email. And 3. Chairs have authority to determine a faculty member's specific assignments and workload expectations per University Policy ACA.FG.300.015. In the proposed remedy section, you should list what the panel recommends as a remedy to the grievance concern. And for each remedy, you should suggest proposed deadlines for the remedy. In this example, the proposed remedy is for the grievant to meet with their chair to clarify workload expectations with a proposed deadline of 10 working days. Keep in mind that the proposed remedies are recommendations that will be submitted to the chair of the Faculty Grievance Committee, with final disposition being determined by the provost. Once you've completed the findings document, you must submit it via box to the corresponding box folder. That is, the folder that is named with the hearing number assigned to the case within 20 working days. See Faculty Grievance Policy, Section B2D11.
It may be helpful to provide an overview of the faculty grievance process under the Faculty Grievance Policy at the University of Mississippi. First, the Faculty Grievance Policy is only applicable and available to persons with faculty employment status at the university who do not hold an administrative appointment at the rank of chair or higher. Second, the grievance policy only applies to a prescribed set of employment-related issues. The grievance process begins with an attempt at informal resolution. In this phase, the grievant, the person with the concern, reaches out to the respondent, the person responsible for the decision or action at the heart of the concern, to see if there can be an agreement reached between the two parties. If that conversation doesn't result in a satisfactory outcome, the grievant must then reach out to the supervisor of the respondent to request a meeting between the three parties. If that meeting does not result in a satisfactory outcome, the grievant may decide to pursue the formal portion of the grievance process. The formal portion begins when the grievant completes an official grievance form, in which they state their concerns specifically and share the evidence that they feel supports their claim. That form is filed with the Faculty Grievance Committee, with a copy also provided to the Provost's office. The Faculty Grievance Committee is charged with determining whether or not the grievance as filed is in fact a grievable matter under the policy. They do that by looking at both the subject matter and the employee status of the individual filing the grievance. The decision of the Faculty Grievance Committee concerning grievability is not subject to appeal. Assuming the matter is determined to be grievable, we then turn to the hearing phase. This is where you as panelists come in. A hearing is conducted in accordance with the Faculty Grievance Policy. The hearing is conducted in a way that allows both the grievant and respondent to present their concerns about the situation and any evidence that they wish to share. The grievance is heard by a panel of faculty members chosen at random from a pool of faculty who are appointed by their schools to serve as panelists. Upon completion of the presentation by both the grievant and the respondent, the faculty panel deliberates in confidence in order to reach findings, which are a decision as to whether or not The grievance should be upheld, and any recommendations regarding how to resolve the matter. The panel puts these findings and recommendations into their report. That report is filed with the Faculty Grievance Committee and is forwarded to the provost. At the same time, it is shared with the grievant and the respondent. That concludes the hearing portion. Next comes the decision portion. The provost receives the panel report. In the provost decision, they are to be guided by the report. If they have any question or concerns about matters in the report, the provost is to meet with the panel in order to review those concerns. When the provost makes their decision, if they decide to deviate on any substantive matter from the report, its findings or its recommendations, the provost is required to submit their reasoning for the deviation in writing. The provost is responsible for notifying the grievant and the respondent, as well as the Faculty Grievance Committee, of their decision. As a panelist, your direct responsibilities are in the hearing portion, but you also have broader process responsibilities that extend throughout your time as a panelist, whether you're actively sitting and hearing a case or not. You're expected to engage in the highest ethical fashion, respecting the confidences of all of the parties and of the process. You're expected to be impartial and thoughtful in your deliberations and actions. This has been an overview of the faculty grievance process under the Faculty Grievance Policy. We hope it's been helpful to you as a new panelist.